Today's newsletter deals with mandatory medical procedure and or treatment and what your rights at common law, under statute, and under the Constitution are with respect to not being able to be forced to undergo any medical procedure or treatment without your expressed informed consent. Hi, I'm Rocco Galati, Executive Director of the Constitutional Rights Center. It's nice to speak to you again. We had a great response to our last newsletter on your rights in the context of masking. After today's newsletter, in about 5 or 6 days, I will be following up on that theme, but directed at independent store owners and business owners. We've had a lot of requests from business owners to please explain to them their rights and duties under the masking laws. And I'll do that after this newsletter. Today's newsletter deals with mandatory medical procedure and or treatment and what your rights at common law, under statute, and under the Constitution are with respect to not being able to be forced to undergo any medical procedure or treatment without your expressed informed consent. Now, a medical procedure or treatment is anything that affects your medical health, whether physically or psychologically. That is your physical and psychological integrity, which is also protected under Section 7 of the Charter under life, liberty, and security of the person. The current COVID-19 measures see 3 types of medical treatment or procedure that I'm going to deal with today. Mandatory vaccines, which have already been rolled out to some government agencies, especially frontline workers who work for government. Secondly, compulsory COVID testing, if and when it arises. And thirdly, masking. So generally speaking, the governments have been hiding behind the fig leaf that none of these measures are specifically mandatory, except that if you, quote, choose not to comply, you lose the right to travel, buy food, and any right to medical services. So they are de facto compulsory, depending on your situation and circumstances. Now, at common law, before the patriation of our Constitution, administering medical procedures without expressed informed explicit consent was considered an assault, and liability and damages ensued. So if a doctor or surgeon administered medical procedures or treatment without expressed informed consent, he or she was liable in damages. Now, this right has been codified in various provincial health consent acts. So for example, in Ontario, the Health Consent Act of 1996 under Section 10 reads, "A health practitioner who proposes a treatment for a person shall not administer the treatment and shall take reasonable steps to ensure that it is not administered unless A, he or she is of the opinion the person is capable with respect treatment and the person has given consent." So under Section 10, a person who's capable of giving consent has to give consent before any of procedure or treatment is administered. Under Section 20, the same consent has to be given on behalf of somebody who does not have the capacity to consent by virtue of mental illness or incapacity or age, a child, for instance. And so the same law applies there. The parent has to give consent if it's a child. Now, so you have a common law right and you have a statutory right. And expressed, informed, explicit consent means just that. Number one, you must be informed of the procedure and treatment before it is administered, including the possible side effects it may inflict. 2, you must express your consent orally and or in writing. And 3, consent must be completely voluntary, asked of your free will, absent of any threats, compulsion, or deceit from the person seeking that consent. Under our law in Canada, this expressed informed consent cannot, and I repeat, cannot be, quote, implied, as fraudulently put forward by the WHO recently with respect to vaccinations at school when it stated that consent may be implied. Quote, the World Health Organization said, an implied consent process by which parents are informed of imminent vaccination through social mobilization and communication, sometimes including letters directly addressed to the parents. Subsequently, the physical presence of the child or adolescent, with or without an accompanying parent at the vaccination session, is considered to imply consent. This is absolutely fraudulently bogus. It does not apply in Canada. In Canada, you do not have any doctrine of implied consent when it comes to medical procedure or treatment. It has to be expressed. So, if you're looking at that UN document, in Canada, that third option of consent is not applicable. It does not comply with Canadian law, neither the common law, statute, and more importantly, under sections 2 and 7 of the Charter. The fact that government is mandating and purporting and wanting to roll out these mandatory procedures and treatments does not remove the obligation of obtaining expressed informed consent from each of us. Passed our common law as a result of the Nazi regime and horrific eugenics experiments conducted in Nazi Germany following World War II is the 1947 so-called Nuremberg Code, which was adopted by most countries in which medical procedures and treatment and without barring medical procedures and treatment without informed consent. This was banned by the Community of Nations. One of the principles which emerged from the Nuremberg Code is as follows, quote, the voluntary consent of the human subject is absolutely essential. This means that the person involved should have legal capacity to give consent, should be so situated as to be able to exercise free power of choice without the intervention of any element of force, fraud, deceit, duress, overreaching, or other ulterior form of constraint or coercion, and should have sufficient knowledge and comprehension of the elements of the subject matter involved as to enable him to make an understanding and enlightened decision. Another international document that echoes this requirement for informed consent is the 1964 Helsinki Declaration on behalf of the medical profession around the world. It has similar requirements for expressed informed consent under Articles 25 and 26 of that declaration. In 1982, Canada patriated its constitution. Part of that constitution was the Canadian Charter of Rights and Freedoms. In the Charter, there are 5 rights that speak to this issue of medical procedure or treatment without consent. They are sections 2, 7, 8, 9, and 15. And so section 2 enshrines the right that everyone has the right to freedom of conscience and religion, freedom of thought, belief, opinion, and there are other freedoms of assembly and association. It's the rights in section 2A and B, conscience, religion, thought, and belief that apply to whether or not you choose to have a medical procedure conducted on yourself or not. The other section that bolsters and upholds the right not to be forced to medical treatment or procedure without consent is section 7, which reads, everyone has the right to life, liberty, and security of the person. Now, the Canadian appellate courts, including the Supreme Court of Canada, have determined that injecting any medical drug without expressed informed consent is unconstitutional. For example, the Ontario Court of Appeal, even in the context of violent psychiatric patients, determined that the injection of mind-altering drugs without the patient's consent is unconstitutional. It's our strong view that nothing different holds for vaccines. The Supreme Court of Canada has reiterated this right and principle many times over under the Charter since 1982. And now I'm going to discuss with you how this common law, statutory, international law charter right applies in the context of vaccines, compulsory testing, and masks. So, with respect to vaccines, mandatory vaccines without expressed informed consent are clearly unconstitutional, infringing the Charter as already determined under Section 7 of the Charter by Canadian appellate courts. Where there is a religious or conscientious objection to vaccines, particularly those containing fetal or animal tissue, there's a further violation of Section 2 of the Charter based on conscience, religion, and creed. Many people object to those type of medical tissue being injected into their body on conscientious and religious grounds. In addition, under Section 7 of the Charter, there are two Supreme Court of Canada decisions which bear and import the Nuremberg Code and the Helsinki Declaration. The first case is the case called Baker, on which I co-counseled with Mr. Roger Rowe in 1999, which established that when you're interpreting Canadian domestic law, it must be interpreted in accordance with applicable international treaty, whether or not we have domestically ratified that treaty. And subsequent to the Baker case, the Supreme Court of Canada decided a case called Hape, where the Supreme Court clearly ruled that any specific right contained in an international document or instrument is read as a minimal protection under Section 7 of the Charter. So it is therefore more than arguable and the case that the rights and protections contained in the Nuremberg Code and the Helsinki Declaration are protected under Section 7 of the Charter. Now, even if they were not, our Charter has already been interpreted to protect your right against forced medical treatment. The only exception in Canadian law to this clear holding and constitutional right, and it appears as an exception, but it is not, is in the case of a minor child that faces an emergency situation where severe, gaugeable harm or death is imminent without medical intervention, and where parents refuse consent on religious grounds. There are several Supreme Court of Canada cases on this, and what the Supreme Court has done is drawn a balance between the religious views of the parents with the rights of the child. And in those cases, by way of court order usually, or legislation by the child services departments, they can override the wishes of the parents and actually apply medical treatment to save the child's life. The threat to harm or death has to be imminent. It has to be gaugeable, it has to be certain, it has to be clear. And so in those cases, while it may appear that there's no informed express consent to the medical treatment, that's a bit of a fallacy, because this exception is consistent with our constitutional framework in that children are not the property of their parents. Children have their own independent Section 7 and 15 Charter rights to life, liberty, and security of the person and to equal protection under the law. And so doctors under those circumstances are also under a legal obligation to save the child's life. Now, so in cases of minors, expressed informed consent is obtained. It's obtained from the court. The court order is that expressed informed consent that allows the doctors to try and save that child's life in those circumstances, in lieu of the parents. Now, this is clearly a complex and controversial issue. However, it does not take away from the principle of the constitutional right to refuse medical procedure or treatment without expressed informed consent, where that person does not have the legal capacity to consent, such as a minor child. Now, when we talk about children, there's also a doctrine which refers to a mature minor, and that is a minor who's in the range of 13 to 16, who sometimes can express their own wishes. This, the Supreme Court of Canada case and these blood transfusion cases has said should not be exaggerated. The common law doctrine of mature minor cannot override the wishes of the parents with respect to consent outside the context of an emergency, threat of harm, or death. Secondly, legislation has also covered this. For instance, in Ontario, if you're 16 or over, you can make your own decision on vaccination or medical treatment, regardless of what your parents' view is. So, statutorily in Ontario, even though it's not the age of majority, for the purposes of consenting to health treatment, if you're 16 or over, you can give your own consent. In the same way that when you're 16 in Canada, you can possess your own independent passport without your parental consent. Now, I now want to turn from mandatory vaccination to compulsory testing. Compulsory testing again breaches the same charter rights and is the opposite side of the coin from injecting something into your body. It's a situation where something is injected to extract something from your body, usually fluid, but more importantly, with that fluid, DNA. This brings into play, in addition to what is covered under vaccines under sections 2 and 7 of the Charter, which I won't repeat, sections 8 and 9 of the Charter. Now, sections 8 and 9 of the Charter read as follows. Section 8 says, everyone has the right to be secure against unreasonable search or seizure. And section 9 says, everyone has the right not to be arbitrarily detained or imprisoned. So, in the context of you being forced to mandatorily test for COVID, you're essentially being detained and having something extracted from you, which prima facie would be unreasonable search and seizure of your bodily fluids and your DNA. That is unconstitutional. There are only 3 limited exceptions to this constitutional right, and they are as follows. The first is the taking of blood in hospital from a drunk driver where doing a breathalyzer is impossible, or where the drunk driver is himself incapacitated, where the blood is taken for medical treatment purposes. The hospital needs to know his levels to see if he's suffering alcohol poisoning, maybe his blood type in the event of a transfusion. So they normally take that blood as a routine course in that scenario. However, even in that scenario, the police has no right to that blood sample unless a judicial warrant is obtained. They need to show probable cause without reference to what's in the blood before the person receives medical treatment to warrant the use of that blood for police purposes. The hospital cannot communicate anything, including the blood results, to the police as a basis to obtain the search warrant. The warrant to obtain the person's blood must be independent of any of the medical treatment he or she receives. The other 2 scenarios that do not involve extraction of bodily fluids, but do involve extraction of DNA, are the taking of DNA from a convicted sex offender for future protection of the public, as studies show that the nature of sexual offenders tends to show that they are repeat offenders. So again, this is done by court order after sentencing for that sexual offense. So you were placed in your DNA is placed in the sexual offender registry, but there is no extraction of bodily fluids. You're simply requested to give a sample of your hair. So any way of obtaining DNA is acceptable. However, again, I want to reiterate, that is done by court order. It's not in every case, depending on the nature and severity of the conviction, that sex offenders are put on that registry. The third and final example is in the civil context, in a paternity suit, where a mother claims child support and a man denies being the father. Again, by court order, the man can be compelled to give a DNA sample to determine paternity for the purposes of support. So now, I'd like to turn to masking. There are some who argue that being forced to wear a mask is not a medical procedure nor treatment, and say it is akin to being forced to wear a seatbelt. This is a fallacious, ridiculous argument for many reasons, including: number one, a mask, depending on your condition, can pose an imminent physical health risk, as well to some a psychological risk of harm. A mask affects your breathing, and in and by itself poses a risk. In the context of children, experts, including the Hospital for Sick Children, have warned of permanent psychological and developmental damages of wearing a mask, in addition to the physical risks of wearing a mask long term. It is also ridiculous to argue that wearing a mask is not a medical procedure when the proponents of mask wearing say it is to protect your health. So I don't know the rationale behind that. Okay, a seatbelt in no way endangers your health psychologically or physically. A seatbelt is there for protecting from physical injury in case of an accident. The mask does not come into this realm of analysis. So it either is or is not to protect your health. If it's to protect your health, physical or psychological, it is a medical procedure that they are insisting that you undertake, that is subject to the same charter analysis that I went through with respect to mandatory vaccination and mandatory testing. Now, the science of masks and their efficacy and dangers are backed up by an avalanche of random controlled studies, which are the only scientifically recognized studies, as opposed to, quote, observational studies, which are based on anecdotal studies and sheer opinion, which have been touted mostly after the WHO reversed its opinion that masks were not recommended for COVID, to now everyone being forced to mask everywhere at all times, including when engaging in sex, according to Canada's National Public Health Officer, Dr. Tan. Again, masking engages your Section 2 and 7 Charter rights in violating your freedom of belief, conscience, and for some religion, in forcing you to wear a mask against your will. Masking also infringes your very life, liberty, and security of the person, in literally restricting your breathing and dictating how to breathe, which is the very crux of life itself. Now, many of you have emailed and left messages on the center's voicemail saying that, yeah, but all this is fine and dandy, but the government under Section 1 of the Charter can do whatever it wants, because Section 1 says they can limit any right, or they could pass legislation invoking the Section 33 override. Well, it's not as clear-cut as that. If it were, there'd be no need for the legal profession. So when you read Section 1, it reads, the Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it, subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. Now, if you read that literally, you would think that they can do whatever they want. Well, no, there is a test that is the subject to a literal deluge of jurisprudence, case law, from the Supreme Court of Canada and other appellate courts interpreting that section. And essentially, once you establish that prima facie, on the surface, a charter right has been infringed, and the onus is yours to establish that, the onus then shifts to the government to justify the infringement under Section 1 of the Charter. In order for the government to justify the infringement under the Charter, it has to go through essentially a two-part test, in which the second part of the test has three branches. And so I'll read to you from the Supreme Court of Canada what that test is. Supreme Court of Canada, in the seminal case of Oakes that established this test, states that to establish that a limit is reasonable and demonstrably justified in a free and democratic society, two central criteria must be satisfied. First, the objective which the measure responsible for a limit on a charter right or freedom are designed to serve must be, quote, of sufficient importance to warrant overriding a constitutionally protected right or freedom. What this means in the context of COVID is that the government would have to establish to the court's satisfaction that the emergency was justified on scientific and medical basis. In our statement of claim, we contest that. We say there was no scientific or medical basis to justify the emergency. The Supreme Court says that this valid objective has a standard that must be a high one in order to ensure that objectives which are trivial or discordant with the principles integral to a free and democratic society do not gain Section 1 protection. And so what we have here, if you think about this, is that essentially democracy has been shut down. We have martial law in a lot of countries. We're getting close to it here in Canada. So I contest that the government could meet its onus on the first arm of Section 1 of the Charter. But even if the government can establish to the court's satisfaction that there was a valid objective, it then has to satisfy the second part of the test, which we refer to as the proportionality part of the test. Supreme Court of Canada says, second, once a sufficiently significant objective is recognized, then the party invoking Section 1, the state, must show that the means chosen are reasonable and demonstrably justified. This involves a form of proportionality test. Although the nature of the proportionality test will vary depending on the circumstances, in each case, courts will be required to balance the interests of society with those of individuals and groups. There are three important components of the proportionality test. First, the measures adopted must be carefully designed to achieve the objective in question. I pause there to say the COVID measures don't meet this first arm. Secondly, they must not be arbitrary, unfair, or based on irrational considerations. Again, I think these COVID measures fail that test. Secondly, the means, even if rationally connected, should impair as little as possible the right or freedom in question. So, in other words, your measures can't be worse than the threat, all right? The Supreme Court says there must be a proportionality between the effects of the measures which are responsible for limiting the charter right or freedom and the objective which has been identified as of sufficient importance. Just in a nutshell, in our view, the COVID measures are like taking a sledgehammer to try to kill a fly on a glass table. They're not proportional. They're arbitrary, they're flippant, they're countervailing, they're illogical. It would not meet this test. Okay? And the Supreme Court of Canada, lastly, says with respect to this third component, says that the measures, even if they meet all the other hurdles that I've just recited to you are still unconstitutional if the deleterious effects of the measures outweigh the beneficial effects of the measures. So in other words, if the damage is greater than the threat, or the damage is greater than what you get out of these measures, it does not meet Section 1 of the Charter. And the state cannot justify those measures in those circumstances. So, just to summarize, in our view, on the scientific evidence available, most notably the morbidity data rates, which are no higher than the average flu season. That is, no more people have purportedly died from COVID, even under fraudulent characterization of a COVID death, i.e. if you're dying of cancer in your last days and you have COVID, they put you down as a COVID death. Even on their statistics, they do not amount to deaths which exceed the annual average flu season, complications from the influenza. The other facts to weigh in here is that the virus has not been isolated, purified, or identified, and therefore cannot be tested for. These PCR tests do not, I repeat, do not test to identify a virus. All they're testing for is RNA and DNA fragments. They do not identify a virus because the virus itself has not been cataloged. And so you have a bogus test essentially, and what you see every day in the media is not a comparison of so-called COVID deaths as a ratio to the population at large and whether or not we have more deaths in society this year than last. All you're getting is these out of context cases, quote cases, testing results which are suspended in midair, meaning nothing. They mean nothing because they're not testing for the virus. They're not correlated to the death rate as a result of their testing. So the only true measure of how severe this so-called pandemic is, how many deaths have we had, for instance, in Canada on their calculation vis-a-vis the population of Canada. So at over 9,000 COVID deaths, which is not far from the annual complications from flu deaths, compared to 37 million people, that is a ratio of just under 1/4% morbidity rate vis-a-vis the population. Well, that is in accordance or even slightly under some bad flu seasons. The other thing that has to be kept in mind also is that after justifying statutorily why there's been a why it was called a pandemic, and justifying the measures in accordance with the analysis set out by the Supreme Court of Canada, it's still perplexing and surprising how the government is going to justify the fact that they refuse to disclose the scientific and medical advice they're receiving and from whom, and refuse to give us a hint as to why the massive crowds of international eminent experts who disagree with these measures and who disagree with the conclusions of the WHO are not being addressed. Now, very briefly, some of you have also said, well, what if they just pass legislation under Section 33 of the Charter, the so-called override provision, in which they can just override the charter rights that I'm citing as being breached by these measures. And Section 33 of the Constitution Act allows them to override the rights contained in Sections 2 to 15. However, this is also a bit of misunderstanding and limited understanding of our constitutional framework. Even if they overrid these, which would require full debate in the legislature, these same rights are some of these same rights are duplicated and recognized and were recognized as unwritten constitutional rights under our Constitution before the patriation of our Constitution in 1982. So these are rights, constitutional rights recognized as pre-existing, and they exist both in our Charter and as unwritten constitutional rights with different contexts and analysis. So to give you an example, the right to an independent judiciary was recognized as an unwritten constitutional right long before our patriation, and has now been read in and duplicated under Section 7 of the Charter. The right to freedom of expression, conscience, and belief and association were recognized as constitutional rights in the 1950s by the Supreme Court of Canada in the Jehovah's Witnesses cases that were decided by the Supreme Court. The right to physical and psychological integrity, wrapped into, quote, the liberty of the subject, was recognized and protected by way of habeas corpus. Habeas corpus has its origin in the Magna Carta of 1215 and now re-encoded under Section 10C of the Charter. The right to equal treatment was recognized prior to the Constitution Act 1982, emanating from the rule of law, and is now re-enshrined under Section 15 of the Charter, except that the Charter right attaches to the personal attributes of the person invoking it, but as an unwritten constitutional right, it simply is recognized that every individual has the right to fair treatment and protection under the law. So, what is of importance is that these constitutional rights that were recognized prior to the Charter are not subject to Section 1 of the Charter, and they're not subject to a Section 33 override by the legislature under Section 33. And this is driven home by Section 26 of the Charter, which itself reads, quote, the guarantee in this Charter of certain rights and freedoms shall not be construed as denying the existence of any other rights or freedoms that exist in Canada. So what Section 26 of the Charter says is that you cannot interpret the Charter rights so as to diminish pre-existing constitutional rights that existed before the Charter was enacted. It would be counterintuitive. And an example of this idea and rationale was the Adler case, where Muslims and Jews in Canada applied to the court for equal public funding to the Catholic and Protestant schools under Section 15 of the Charter. And the Supreme Court of Canada said, as lamentable as it is that other non-Catholic, non-Protestant school boards do not have equal public funding, you cannot interpret Section 15 of the Charter to undo the right of Protestant and Catholic schools under the old BNA Act, which is now the Constitution Act 1867, to their public funding. And so this idea and rationale has already been enunciated by the Supreme Court. Now, the last thing I want to talk about today, which is not related to medical procedure or treatment, is the contact tracing that's going on. Now, information on your cell phone, all and any information on your cell phone, cannot be released without your consent. If the government took that information, wants that information, the government would require a judicial search warrant. So nobody can force you to hand over your information on your cell phone. They need a warrant for it. However, what gets complicated, and what's already happened, is that the service provider, the person who provides you the services on your cell phone, also without your consent, cannot hand over information on your cell phone. Unfortunately, a lot of Canadians have been duped when the new when the new cell phone programs were sent automatically, when you hit I agree, contact tracing, you've already agreed to that contact tracing if you have one of those phones. So to the extent that that contract on your cell phone would be declared binding as between you and your service provider, then your service provider can hand over all that information to the government without a search warrant, because you have deemed to have consented to that when you hit yes, give me the new updates on my phone. And the fact that you didn't read the fine print may not carry the day in a court. So if you're concerned about that, you can just throw away your phone forever or get another one without the contact tracing agreement. But you'd have to be specific with your service provider that you do not agree to any contact tracing. So I hope you found this video useful and informative. It is meant for general information and education purposes only, and not meant to be taken as specific legal advice on any particular fact situation. In law, we have a saying, the facts determine the law. And so it is not meant to be a general apply all in every situation opinion, or rather legal advice. This is meant for you to know your constitutional rights, to know your rights in general. In my next newsletter, I'll be reviewing, as I said earlier, at the request of a lot of independent business owners, what their duties and rights are under the masking bylaws and provincial legislation, and particularly in Ontario. This other newsletter will be out in 5 or 6 days. I want to thank you for listening, and subscribe to our newsletter and YouTube channel, and please, if you can, financially support the work of the Constitutional Rights Center. Thank you very much.